So in my short presentation here, that I will try to cover how complaints are handled by medical boards and what type of complaints that we receive, how do we prioritize complaints, and some of the hurdles the medical boards actually go through in effectively processing those complaints. And one disclaimer that I will not be presenting anything on any or even commenting on anything on any active investigation currently the board is handling. And just to answer the question about the Federation of State Medical Boards recent press release about the misinformation about COVID, yes, we did get that, and we are actively considering coming up with some policy guidelines. And towards the end of my presentation, I will touch base on some of the COVID-related complaints that we received and what are the hurdles that we are going through. So without any further ado, let me minimize this. And okay, so when we look at any medical board's mission and vision, it is primarily to protect the healthcare consumer. And so the two fundamental functions of any medical board, they are to protect the public through proper licensing and objective enforcement of the Medical Practice Act. So both functions, again, have one common goal, and that is public protection by promoting access to quality and safe medical care. So how do we achieve that in California? The law, the Business and Professions Code, section 2001.1 dictates that even if there are other factors that are germane in the case, protection of the public shall be the dominant factor. So it doesn't matter what other competing factors are present, we always look at ways to protect the public. So just to give you some baseline statistics as to, this is just California complaints, and we back in fiscal year 18-19, so the most complaints ever lodged with the board, 11,407 complaints in a 12-month period. And that started to drop in FY 19-20, FY 2021, the fiscal year that we just finished this June. We saw 10,103 complaints. And part of the reason why we saw a decrease in the number of complaints filed mainly due to COVID-19 consequences. So meaning like the clinics are not open. There are not that many outpatient clinics that are open for patients to go to because of the law decided to shut them down or during the lockdown and what so. And so that may be the reason, but definitely saw a decrease, which may or may not be the case going forward. So during this FY 2020, FY 2021 period, we opened about 1,063 investigations and about 453 disciplinary actions were imposed. And you would think that that is a very small percentage of the total complaint of 10,103 that we received. And that's what usually the public, media and the others would be releasing in the story as a catch-all headline that the medical board is not effective because they only take about 3 to 4% of the total complaints filed actually go through the scrutiny and some form of disciplinary action. I'm here to tell you, yes, some people believe that every patient death or every medical mishap would require a physician's license to be revoked. That's the ask. But as you know, judges and distinguished guests in this panel or in this conference, that that is not the way the system operates. Especially when you consider that 42% in this last fiscal year, 42% of the complaints that we received are closed because they are unactionable. And let me kind of get into what that means. So why do we close complaints? It's not simply because we don't want to do anything about it. It's because we cannot do anything because of these reasons. Like out of that 42% of the complaints that we closed, there were about 4,183 unactionable complaints. And what are those unactionable complaints? Because they are not in our jurisdiction, meaning like in California, we license medical doctors primarily and few other allied groups. And but we do get complaints on nurses, physician assistants, physical therapists. Of course, we cannot do anything about it. So those are processed and handed over to those boards that do have jurisdiction over those professions. But there are also redundant incidents. We received about 1,190, like meaning one news story on one incident, medical mishap, could generate multiple public complaints. Well, those are not individual complaints and individual cases that will open. It's one complaint and one mishap. So we call them duplicative or redundant complaints. And there are also inadequate evidences or insufficient evidences, and sometimes there's no violation. And some of those insufficient or inadequate evidence could also mean that the inability for the medical board to obtain the medical records, which we'll go through here in a little bit, because simply in California there's a Patient's Privacy Act. Based on that, if the patient refused to sign a release, we are not able to obtain the medical records. We'll have to go through a court system to get it. And sometimes that's easy, sometimes it's very difficult. And there are also anonymous complaints received where we do not get any response from the complainant after the first complaint that they lodged, and that amounts to about 1,551. So these are the areas where we get about 42% of our complaints. Now, there are some fascinating numbers and statistics on our annual report, and this slide deck, I understand, would be on Dr. Sandbar's website, and here's the link at the bottom of this slide that will take you to the most recently published 2020-2021 annual report of the California Medical Board. So how do the medical boards prioritize its complaints? The board prioritizes it complains by giving immediate attention to complaints involving sexual misconduct, gross negligence with patient deaths, impaired physician, excessive prescribing, and finally, practicing medicine under influence of drugs or alcohol. So if these elements are present in a complaint, those complaints will get some priority handling. So what are the top 3 complaints that we see? Basically, that involve gross negligence. That means extreme departure from accepted standard of care, physician practicing in the areas that they do not have any knowledge or training. We see that very common in pain medication or in cosmetic procedures or medical spas. The physicians, there's a quick money, some cases where they would launch into that practice where they have no basic medical or school or postgraduate training at all. And they go from one discipline of medicine to such quick money-making deals. Then they end up hurting the patients, and we see a lot of that. And then we also see unprofessional conduct, personal conduct, and this can be a mixed bag of infractions, anywhere from sexual misconduct, failure to release medical records, self-abuse of drugs and alcohol, criminal conviction, etc. And then we also see complaints in the areas of excessive prescribing, which is self-explanatory what that means, and including excessive prescribing and also sale of dangerous drugs. And I vividly remember a case here in California where a physician used the service of runners that would go out and get Medicaid or Medi-Cal, here what we call Medicare patients and recipients in California. Runners would go get them, round them up, bring them to the physician, and the physician will do all the history and physical, their x-rays and and use their medical records to fill narcotics. And instead of giving the narcotics to the patients, the physician would end up selling that. And the patients received $250 for the trip. And the physician made millions of dollars before himself was put into jail and his license is revoked. So that's a sale of dangerous drugs, and it also falls into that excessive prescribing aspect of it. So top 3 violations, and as reported in the board's annual report that I mentioned earlier, these are the areas that we see where we see the top 3 violations happen. That's gross negligence, incompetence, self-abuse, drugs or alcohol, inappropriate prescribing. And going over to complaint categories, um, um, it can be classified into 7 categories. Now, please don't equate this to, but you will see some correlation between what I'm going to share here, and if you want to take a quiz on it, how this is related to the 7 deadly sins, be my guest, but I'm not going to make that happen. But basically, they fall into sexual misconduct, sexual exploitation of the patient-physician relationship, failure to maintain medical records, not examining the patient appropriately and doing the pre-work, not taking the time, rush into the treatment, false and misleading advertisement, which we see it's a very common thing, and then also disruptive behavior. And when I talk about disruptive behavior, it's not just lashing out with words, actions, hostility with the patients, but also with the staff, co-workers, other physicians, and all kinds of settings. It could be in the clinic, in the hospital floor, on the hospital floor, ER, in the operating room while the patient is still on the table, throwing things around and showing very tender tandem. We see a lot of that in the complaints, and those are reported by other physicians. And we also see addiction to drugs and alcohol, fraud, upcoding and using corporate practice of medicine and prescribing for cash, and also not taking and not asking for help or any kind of consultation, and because they're always correct and not open to other views or second opinions and taking care of their patients. And especially we see that in most of the time with pain management, where the physician refused to or sometimes don't want to release the patient to an acute in a chronic situation, to refer the case over to a pain management physician or consult with one. So these are the 7 common areas that we see complaints that are coming to us. So what does the investigation process looks like? So it can be classified into the 6 areas, and basically every board investigation begins with a complaint, of course, and we just don't go out there and recruit complaints. It all starts with complaints filed with the board, and the board relies the ability to obtain medical records is very important. The board obtains the medical records and use them as the basis for its case. The medical records are, once we are able to obtain them, initially sent to the medical consultant, who reviews the medical record and makes a recommendation. If it is the medical consultant's opinion that the case requires further investigation, the board send the case to the field for formal investigation at that time. One of the challenges that the board faces in California, I'm sure this is the same with other boards too, we definitely had our share of problems in Oklahoma too, is when investigating the cases, is that obtaining the medical records itself. There is no law in California that easily grants the board's access to the medical record. Like I mentioned, if the patient did not sign the release, then we'll have to go get a order from the court to subpoena the records and compel the records to be produced. And either the patient or the representative have to sign, otherwise to release to records to the board. So there are other areas apart from the medical records, other records too, like pharmacy records, for example. It's also important on top of medical records. Pharmacy records from the pharmacies, and those chain pharmacies are not sometimes your friendly people who would readily make those pharmacy records available to you. And sometimes it could be the coroner's report, the ME's, or the ME's reports, or death certificates, or this and that, and other records too, in some cases that we need to obtain. So those are some of the initial hurdles we'll go through. The other areas of limitation in adequately investigating a complaint is the statute of limitations. Now, it's all over the place in the country. In California, it can be either 3 years or 7 years, and I'm not going to go into the details of the law, what those 3 years and 7 years looks like. So once the complaint is received and it's ready to go through the field investigation, and we are going to go on with it, the very first thing we put on the database is what the statute of limitation is. When is that SOL coming up, and that starts the process of how quickly we can get and beat the statute of limitation. And our goal is to file an acquisition before the statute of limitation runs out. Otherwise, the case is no longer viable at that time, and we'll have to just withdraw that complaint or not do anything with it at that time. So that actually dictate the enforcement timeline at that point. Other factors could happen that can extend that statute of limitation, and like I said, it's all over the place, and we don't have the time to go through that in 30 minutes here. In California, we do have a unit called HQIU that is part of our Department of Consumer Affairs. It stands for Health Quality Investigations Unit. They primarily are the unit charged with SON investigators who can handle complex complaints for the board. And the complaints are, if it is not something that the board's internal complaint unit cannot handle it, then we'll refer that matter to HQIU, and we'll work with them in through the phase of the complaint at that time, and how they are investigating. And like I mentioned, again, those unactionable complaints are written off the books or basically closed by their complaint internal complaint unit. So once the complaint is adequately or investigated and going through the expert review, it'll go into the prosecution process at that time. And here's another problem that we have is the burden of proof is clear and convincing evidence to a reasonable certainty. And a lot of media outlets would like to talk about the board's disciplinary rate, like I mentioned, that, and compare one board to the other, saying, okay, that board's better than this board. But what is often overlooked is the burden of proof in California and in other states where the disciplinary rate appears to be higher, and California could be lower. And I will touch base on that here a little bit in the next slide, basically, where you will see that the well, maybe I should go ahead and mention here the standard of proof is higher with clear and convincing, and only 7 states have clear and convincing standard of care. The other states have either preponderance of evidence or a mixed bag of clear and convincing and preponderance of evidence based on what the nature of the complaint is. So because of the relatively high burden of proof, the board's investigation must be thorough, often taking several years to complete, due in part to the complexity of its case, but also to the higher burden of proof too. And so that's one of the reasons why there's a low rate of cases going to a ALJ hearing or some type of final disposition by the board. Again, not to water down everything that you hear in media and others, but that is a reason. So COVID-19 complaints, and just coming to the end of the discussion here, and since the COVID-19 hit about 2 years plus, to date we received this many complaints. And this is total number of complaints. I mean, there were some duplicate, but there's no duplicate complaints included in here. So 1,334 complaints received. And to date, the board has not disciplined a physician for COVID-19 related offenses. And most of the complaints the board received involve for example, like spread of COVID-19 misinformation that you hear on national and state medias and others, or unproven or misleading COVID-19 treatments, or not enforcing or practicing COVID-19 safety protocol. And there are also other reasons, including the COVID raising concern about licensees posting statements for and against masking, and not only just not wearing masking, but they are also out there posting statements on social media, and also against vaccination, like I mentioned before. And there are areas of not against the doctor, but maybe the staff of the doctor not wearing mask. We have got some complaints on that too. And also, there were some complaints related to outpatient surgery centers that were still in operation after being told to close during the lockdown period. So, so when we all I can tell you is that the spread of COVID-19 misinformation is of particular concern to the board, and we recently, I know the Federation of Medical Board came out with articles on that, and the Attorney General of Nebraska came out with some ruling. State of Washington, state of Oregon actually disciplined a physician recently, and there are other cases too that I don't have a list of them with us right now. But in California, for particularly, we have not closed any of these complaints. We received these complaints, we are investigating them, and we don't have any disciplinary actions yet. But I'm not at liberty to discuss any particular complaint or any particular physician at this junction, and we can only do so if an accusation is filed. So that's where we are, and I would be available to answer any questions during the panel session, and hope that I will yield any time saved to the next speaker at this time.